356 proclamation suspending those two provisos which have no nexus whatsoever to the object to be achieved under 356, clearly collateral. So now I come to interpretation of Article 3 and 4. So the reference I made to Article 355, but some passage from Bomai I must show to your Lordship.
How is the ladies? So this includes.
Para PDF page 155
Of
volume 2. Now kindly see what that para says. This is with reference to Article 355 on which I place reliance. That the purpose of 356 is to restore the state. Para 160. The crux of the question.
Just 1 second. Which page are you reading? 155. 155.
The PDF page 155.
which judgment is this?
Bomai.
Volume 2. Para 168.
Para
160.
160. I think judgment of K. Ramaswamy. The crux of the question is wields of the President's power under Article 356. This has a direct bearing. It finds its birth from a family of emergency provisions in Part 18 of the Constitution. Article 355 imposes duty on the Union to protect states against external aggression and internal disturbance and to ensure that the government of every state is carried on in accordance with the provisions of the Constitution. As a corollary, when the government of the state is not being carried out in accordance with the provisions of the Constitution, a constitutional duty and responsibility is put on the Union to set it right. So therefore, if the machinery has broken down, to set it right means to see that the state normalcy is restored. So therefore, Article 356 cannot be read in isolation. The purpose of 356 is to restore under Article 355. That's the purpose for which. Now, another reason to say the same thing is said by Justice Jeevan Reddy and paragraph 272 and Justice Sawant at para 56-57. I did not read those paras, I'm just giving to your Lordship those parameters. So the sum and substance of Bomai is this, that restore the state to normalcy because that's a duty cast upon you under Article 355. Now there is one more reason to say that the exercise of power under 356 is for a collateral purpose. Because ultimately what they want to achieve, do away with Jammu and Kashmir state. That point I already made. I also said no jurisdiction because the governor had already assumed the powers after the assembly was dissolved. There is one more reason which is to be found in judgment of this court in K.N. Rajgopal versus Karunanidhi. 1972, volume 4 SCC, page 733. PDF page 6869.
Of which volume?
So PDF page 6869, volume 19. It's a one-page judgment, but has seminal contents.
Volume?
19.
Paragraph, there is only one-page judgment. It is volume 19, PDF page 6869. So this is what your lordships have said. We have just delivered a judgment in front of you. A similar question arises in this appeal, but with respect to the Chief Minister and the Minister of the State of Tamil Nadu, the relevant articles are worded similarly. The only difference is that the governor is not elected, but is appointed by the President under Article 155 of the Constitution and under Article 356 of the Constitution, makes a provision in case of failure of constitutional machinery in the state. But when an assembly is dissolved, there is no failure of the constitutional machinery within Article 356, Article 164, which provides that the Council of Ministers shall be collectively responsible to the Legislative Assembly of the state, has to be read in Article 75.3, following our reasoning in that appeal, this appeal was. In other words, what your lordships have said is that once the assembly is dissolved, there is no question of machinery having failed, and therefore consequently there can't be a 356 exercise. So in this context, I invite your lordship's attention to judgment in Gujarat Assembly case. Now, if your lordships have a look at Article 356, there is no provision which says that what is the upper limit. How long you can do away without an elected government. This question came up before your lordship in Gujarat Assembly case. And your lordships have said 6 months. I'll just say that judgment is in volume 19, PDF page.
Page? Volume 19 page?
Does it?
Page, volume 19 page?
I'm just reading. Page 283. Which is the parallel?
Volume 18, page 28.
So kindly come to para 79 on PDF page. The PDF page. 283, sir. 283. Para 79. However, we are of the view that the employment of the words and expiration occurring in section 14 and 15 of the Representation of the People Act respectively show that the Election Commission is required to take steps for holding elections immediately on expiration of the term of the Assembly or its dissolution, although no period has been provided for. Yet, there is another indication in section 14 and 15 of the Representation of the People Act that the election process can be set in motion by issuing of notification prior to the expiry of 6 months of the normal term of the House of the People or the Legislative Assembly. Clause 1 of Article 172 provides that while promulgation of emergencies is in operation, Parliament may by law extend the duration of the Legislative Assembly not exceeding 1 year at a time, and this period shall not in any case extend beyond a period of 6 months after the promulgation has ceased to operate. Further, under Article 123(2)(1)(3) of the life of an ordinance promulgated either by the President or by the Governor, as the case may be, is 6 months, and repeated promulgation of ordinance after 6 months has been welcomed by this court. Again, under Article 109, 110, and 111, and analogous articles for the State Assembly, money bill has to be passed by the House of the People or by the legislature. So the period of 6 months has been read by your lordships. Then there is one more para of in the same judgment. This was of Justice Khare, and there is para 147 in the judgment of Justice Prasad. PDF page 316. So this is the ratio. Para 147. Almost his lordship has echoed what Justice Khare has written in the 79 which I read out. Now I come to Article 3 and 4. Now kindly see the marginal heading. Formation of new states and alteration of areas, boundaries, or names of the existing states. This is a clue. Of course, there is a debate whether marginal headings can be seen or not. But fortunately for us, this issue is no longer res integra, as a constitution bench judgment of this court in Bengal Immunity versus State of Bihar 1955 2 SCR page 603 or AIR 1955.
What will be the PDF page and volume?
PDF volume 13 and page is PDF page is 144, and I take straight away your lordship to para 25.
It can indicate the general drift of the provision, but it cannot be used to supplant the actual statute.
That's correct.
The
I'm not
actual
saying-
words of the provision.
I'm not saying. If there is some ambiguity, and there is in my respectful submission, according to me, there is not even ambiguity, there is a conscious omission in Article 3 as regards power to abolish a state. Conscious omission. So why do I say there is a conscious omission? Not only from the marginal heading, but also look at the text. Form a new state by separation of territory from any state or by uniting two or more states or parts of the state or by uniting the territory to a part of a new state. Minute details, what that power is. Then it further says, increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state. Details are given. What is the extent of that power? There is no ambiguity at all. There is not even a whisper about abolishing a state. And this has to be seen in the light of Article 1. India, that is Bharat, shall be a union of states. 2 also. The Parliament may by law admit into union or establish new states on such terms and conditions as it thinks fit. So Article 1, India, that is Bharat, is the union of states. Article 2, admission of new states. Article 3 gives details of the power that the Parliament has. Now, therefore, there is a conscious omission to abolish a state. My second point,
What happens when you unite two states?
but the point is this, your lordship will see that a territory, what is the idea behind the state? That people in a given territory should have a state government. Two-tier democracy at the state level, and that is how the constitutional scheme is. Some powers are given to the state, list 2. They have their own government. So this concept of a state is inbuilt in a democratic structure that this constitution has built. In other words, the existence of states is a part of the basic structure. And J&K can't be an exception to it. Then why not tomorrow abolish Bengal? By what parameter? that according to me, there is a conscious omission. So Article 1, 2, 3 have to be read together. Now, there is one more reason. This alteration of boundaries, changing the name of the state, uniting two states, one state being divided into number of states, this does not amount to an amendment of the Constitution. True. So all the more reason why this power must be narrowly construed. According to me, no two interpretations are possible. There is a conscious omission to abolish a state because India is the union of states. I link it with 355 and 356. Article 3 has to be read with 355. If there is breakdown of machinery, restore the normalcy. But you can't abolish a state. And since it does not amount to a constitutional amendment, it must be strictly, narrowly construed. And this interpretation, in my respectful submission, would advance the concept of democracy and concept of federalism. Open the Article 18. Article 18. Of my argument. Now forget everything. What is the impact on the constitutional structure where everything has been turned upside down? First, what is the impact? Ladakh under the reorganization has no representative in the Rajya Sabha. People of Ladakh therefore do not count as far as Rajya Sabha is concerned. So much for the democracy. Now look at Lok Sabha. All existing Rajya Sabha. All existing 4 seats in Rajya Sabha go to J&K. Ladakh is left out. Consequently, people of Ladakh have nothing to do with working of Rajya Sabha, including the election of the deputy chairman under Article 89 and 90. Second, look at Lok Sabha. Under Article 81C, all union territories in the country can maximum have 20 seats. In that, you have the J&K. But look at the discrimination. Under Article 81, Clause 2, as far as other states are concerned, the number of seats that they have depends upon their population. And the Constitution further mandates that this ratio between the population and the seats for all the states shall be same as far as practicable. So in state of Jammu and Kashmir, irrespective of its population, it has no proportionate representation in the Lok Sabha. Discrimination. Article 14. Now, if you create some more union territories, that limit of 20 will have to be crossed. Today it is 19, including the 5. That's all right. But look, if working out seats for other states is a different formula. How can this be done? Other disastrous consequences. Look at the election of the president. Come to Article 54 and 55. For electing the president, the electorate consists of members of parliament, both Rajya Sabha, Lok Sabha, and also the legislative members of respective states. Now, J&K is not a state. Therefore, there is no MLA for the purpose of president's election. Now, to the exclusion of such a big area, no say in the election of the president, if not by direct, at least by an indirect method. But I must hasten to add that the Reorganization Act says that J&K will have the same rights as Pondicherry. And Pondicherry under Article 54 and 53 there, but this will require a constitutional amendment. You can't do it by law like this. Other disastrous consequences, Article 279A, representation in the GST Council. People of Jammu, Kashmir, Ladakh have no say as far as that council is concerned. Appointment of High Court judges. As far as other states are concerned, the governor is one of the persons to be consulted, and governor means aid and advice. So that also goes away. There are several such provisions in the Constitution which are impacted. Therefore, by a very small act which apparently looks constitutional, that is Constitutional Order 272, the whole constitutional structure is demolished, substantially restructured with J&K. So I'm grateful that
Thank you, Mr.
I exceeded my time.
No, Mr. Lakshya. Thank you very much. Thank you, Mr.
And
Lakshya.
both Mr. Dave and everybody has argued that consultation contemplated must be effective. That is why elected. That point has been extensively argued. So I'm sorry that I exceeded my 1 hour.
Thank you, Mr. Napre. Thank you.
I thought in the circumstances,
You confirm.
perhaps I was justified. I am grateful, Manu.
Somebody's time will have to get deducted.
Ultimately, whether it's a 20 over, 50 over, the time is allocated to everyone between whatever is available.
How much somebody can bat will depend on the total number of hours.
Since your lordship used the word bat, Lord, it reminds me of my position that this point of time is like that of a night watchman.
No, you're just after tea, actually, so you have a whole session you can resume.
Which is a very delicate job, night watchman, no? He has to sustain the flagging interest also. Lord, I have submissions on 2 issues only. One was what Mr. Nafde was advocating just now regarding demolition of a state into union territory. And only thing I wish to add on what he said was, if Lordship would just have a look at 246(4).
Is it way?
Which matter are you appearing, Mr. Devadi?
रेट नंबर दे दो इनका.
In the first matter, we filed a petition, but we were told to file a intervention application. And then an order was passed on that, we will be heard like any other petitioner. Therefore,
So you are for an intervener,
yes.
which just give us just the reference so that, we can, just for the sake of the record, we need to complete the record.
Lord, it is writ petition number, it is IA number 145.
IA number,
2.
sorry, can you come again, please?
IA number 145
Yes,
852
yes.
dash 53 of 2019. This is in writ petition civil number 1013 of 2019.
Actually, I think forgot to ask.
overruling note inevitably implies that the past practice, whether right or wrong, it will continue to operate and will not be affected by the judgment. But it accepts the fact that if the declaration is made of invalidity of the impugned amendments, then that may have a consequence, and therefore lordships prospectively overrule it. So implicit in this prospective overruling is the invalidity of those supposed invalidity, and therefore lordships try to save it. Now, another way of looking at it is, look at it this way. Supposing lordships accept my viewpoint on the basis of the text and the context, and lordships come to the conclusion that yes, there is a case for this, that the power is not available, and therefore the impugned COs are invalid. Now, in order to prevent the effect from traversing on to the earlier ones, your lordship would ask whatever relief lordships can mold under about 142, lordship would do that. But that doesn't mean, that on the basis of this past, continued exercise of power, your lordships would ignore the text and the context. If the text and the context, as per my submission, inevitably show that yes, the power could not have survived beyond 57, then perhaps there is a case to look into it.
All right. Now, Mr. Dwivedi, should we start with the first point? Because first you have to add on to what has been argued by Mr. So maybe just because we are at about 3:35, so you can maybe in 5 or 10 minutes conclude the first point.
What I wanted to add was, apart from what my friend had said, additionally, if your lordship would just have a look at 246(4). Lordships have had a look at it on several occasions, but then my friend perhaps omitted to see it. 246(4). Parliament has power to make laws with respect to any of the matter for any of the territory of India, which is union territory, not included in a state, notwithstanding that such matter is a matter enumerated in the state list. Now, that's the inevitable consequence of when you break down the state into a union territory, then Parliament is the sole legislature. Now, when Parliament becomes the sole legislature, inevitably, the state comes out of the federal structure. Because lordships have said, Article 1, and my friends read some part of it, I can read some part of it too. Article 1 says India is a union of state and refers to Schedule 1. I feel lordship would just have Schedule 1 for a moment. Now, Schedule 1 specifies the states in Article 1 and 4. First schedule. It specifies the states, and Kashmir is there at item 15. And then, it goes on to have item 2. The lordship would have 28 states, then item 2, union territories. These are not specified as states. Now, though they are part of territory of India, as per Article 1, yet when it comes to federal structure, union territories are not part of that federal structure. This is there are decisions I have referred to in my judgment, the decision to that effect, that Article 1 does not contemplate union territory constituting part of federal structure. And for obvious reason, if your lordship would recall the definition of federal structure in our constitution given by Dr. Ambedkar, he said there has to be a dual polity. And that is how he declined the entire objections to the Constitution of India as being unitary and not being federal.
Now there is a nuance on that. Following the NCT judgment,
yes,
we have placed Delhi in a different.
And I was coming to that only. It goes further.
Position.
what your lordships has said goes further. What it says is that dual polity contemplates that citizen of every state is entitled to be governed by the laws made by two different legislatures. That's the concept of dual polity. Where for local issues, the right is for the local to get himself governed by the local legislature on local issues. And so far as the national issues or bigger issues are concerned, Parliament. That right gets defeated. And therefore, the dual polity gets lost as per Lordship's judgment. States are not appendages, as the Lordship said, not satellites of the Union. They are their own plenary selves created under the Constitution, not the Parliament. So this results in the demolition of the entire dual polity and therefore destruction of the federal structure. And no one can say, Lord, the Jammu and Kashmir did not satisfy the requirement of federal structure. Our federal structure is not defined, but there's an interesting aspect which I wanted to bring to your Lordship's notice in this regard. Lord, all throughout, we have been hearing about the quasi-federal character and so on and so forth. It's not truly federal as the American system in our constitution. But in each of these judgments which say so, what your Lordship would see is they omit to notice the Constitution of Jammu and Kashmir. And when we come to Constitution of Jammu and Kashmir, it goes one step ahead of any other constitution. And that is this. It is the Constitution of Jammu and Kashmir in our federal structure which lays down the parliamentary jurisdiction. It lays down the parliamentary jurisdiction under the commitment given by the framers of the Constitution and the Dominion of India. It lays down the tone and terror of the state and the union relations. Finally, that's what the framers have said. And then have a look at Section 5. Because if we don't accept this fact, then Section 5 becomes, which is according to me, the soul and heart of the JK Constitution. That gets absolutely demolished. That's the basic structure of the JK Constitution. And Section 5 says the power of state would be not on any subject which is given to the Parliament. Parliament has been given enumerated powers, that is entry 1 to 96. And not 97 and Article 248. So which means residuary entry is not there. Rest of the entries 1 to 96 are there with Parliament under the Constitution of JNK. The concurrent list and the state list are with the state, except to the extent that correspond to the instrument of accession. Now, can you look at this note? Here is a case where the state is going to decide what is the jurisdiction of Parliament and what is the center-state relations, scope of that. So that's the extent to which the autonomy was given to JNK, guaranteed autonomy. And to borrow Dr. Rajiv Dhawan's phrase, it is democratization of power in India in the shape of autonomy. He referred to various provisions, various levels of autonomy was given. Now, here is a case where the level of autonomy is stupendously raised. But nevertheless, it is part of federal structure. We can't deny because Article 1 and the schedules say so. But by reducing that state into a union territory, what we are doing is we are bringing it under 246(4), where the people of the state, both the union territories now will have only one legislature, both for local and the national issues. The right to be governed under a dual polity goes for a toss. And that is how we'll have to see section 3, article 3, I'm sorry. Berubari gives a clear indication. I'll show that passage. But that is how we'll have to see. The power is limited. We can't, the amendments that have come is only for a specific object. And the object amendment in the, by adding the explanations to article 3. They have come for a specific object of overruling the Berubari case, to the extent it said that union territory is not governed by it. So to that extent they overrule, but the remaining part of Berubari judgment which says that states cannot be, they don't have a territorial integrity, the word used. But then they cannot be, they can be addition to the state, they can be subtraction from the state by giving it to another state. That way, what you are conferring is the dual polity. Whenever you change the territory of the state, you are retaining the dual polity for the citizens. Because from this state, they go to another state where the dual polity continues. But then by demolishing it, what we are doing is reducing and demolishing the dual polity into a unitary system under 246(4). That is what I wanted to add to my friends. And I have in my written submissions, given the host of cases where lordships have said this federal structure cannot be disturbed.
Now you go on
This
to the-
is
Yes.
my written submissions. And this is, I would request lordships to see page 44 and 45 in that regard. 44, 45. This is at page, as my friend correctly noted, I have given the internal page, page 40, page, PDF page, no.
The written submission volume.
What is the PDF page?
394.
The internal page is 44 and 45. So therefore, I submit with respect, Article 1 completely excludes union territories, and therefore, once you reduce the state into a union territory, you deprive me of my right to be governed by two legislatures. That's the crux of the dual polity. Internal page 44 would be at page 437 of the PDF.
437.
437. And I'm only referring to page 44 to 46, and I've referred to a host of judgments, which lordships are clearly aware of. No? But basically, referring to two last judgments, if lordship would see, at page 46, internal page 46, two last judgments, no? Of which one of the Chief Justice was a partner, 2017-12 SCC 1, this is general, and then 2018 volume 8 SCC 501, and I have given the paragraphs too.
2018.
2018 volume 8 SCC 501, and I've given the paragraphs also in the PDF.
There. Yes.
And then there is another page, lordship may have, no? 46 and 47, internal page.
Yes.
That is what I wish to add. No? Now, before I proceed, Lord, there were two issues which were rankling in lordship's mind, Lord, from the very beginning, first day. One was, in fact, two from your lordships, and one from Lord Justice Khanna. Lordship had an issue with regard to sovereignty, and the observation was that once you accede to the dominion of India, you surrender all your sovereignty. Now, lots of things have been, I'm already informed you, just that instrument of accession would not amount to surrender unless there is a merger agreement which says that you merge your sovereignty, as happened in the case of other states, which I will show. The other states had not only not acceded before 15th of August 47, they had signed as a precondition made by the Dominion of India that they will sign the standstill agreement also, which covers the matters of local concern. And after that, Lord, they acceded to the Union of India. Thereafter, Lord, they further, when they merged with the adjoining states, the adjoining provinces automatically merged, provinces under the Government of India Act, they automatically merged. Indian states merged primarily with the provinces, or they formed their own federation. Then they were directly administered states also. They all not signed the merger agreements with the Dominion of India, conceding all their powers of legislation. And that is why, Your Lordship would see Article 238 was incorporated. Article 238, Lord, expressly applied Part 6 and 7. And of course, consequently, Part 11, which is 245, 246, 254, and so on and so forth, to all the other Indian states. But when it came to Jammu and Kashmir, Lordship would have noticed note that in 370, clause 1, to 38 is excluded. This is despite the fact, Lord, what is important is this is despite the fact that the Kashmir was placed as a Part B state in the schedule that point of time when the constitution was enacted.
It's now on the new point. It's about 10. Roughly, how long would you take? Because we are starting the new point, the second,
Not more than an hour, no? Not more than an hour.
Would we,
I tried to.
Could we,
But some things have been
because we'd
said.
like to conclude the submissions on this side on Tuesday.
Quite right.
Frankly, I'll tell you, now we've got so much of information from you, we'd like to put it to the other side and get
Information
responses. I
overload.
think you have,
No, but my situation is not, I'm like a
now
pariah. Not
just-
my friends are on different issue. I'm on an
No,
entirely
no.
different issue.
if you could really put it down in say about half an hour or so, so that we can push through on Tuesday and
I try my best.
after Mr. Dwivedi, who will be arguing? Mr. Singh, about half an hour or less. You've prepared your written submission. Your written submissions are there, right? So what we'll do is on Tuesday, frankly, I had not seen your submissions over the weekend. We'll look at your written submissions so that then, you know, your time is then, because we'll be completely ready with your background.
Can I make a request?
Cut it down to half an hour, Mr. Singh. Otherwise, you know, we'll not finish this side on now.
See, Mr. Seil Singh, see, Gopal Shankar Narayan has been sitting all this time. Therefore, he must now decide who is speaking and how long they are speaking, because the Gullentine will apply on Tuesday, certainly. Therefore, it should not be that one person takes an extra time, then other people don't get a chance to speak. This is the problem.
So therefore, half an hour
Certainly, it'll end on Tuesday.
and half an hour for Mr. Dwivedi, half an hour for
Supposed to
Mr.
be a
Seil
liberal
Singh.
time period even by any standards.
And after Mr. Chandra Singh, who will argue? Mr. Gopal Shankar Narayan.
My name has been there after Mr. Singh.
So what we do is, Mr. Dinesh Dwivedi, Mr. Seil Singh, Mr. Gopal Shankar Narayan, and Dr. Menaka. One second. We are laying down a time schedule. The four of you, between yourselves, please ration the time so we complete your submissions by lunch on Tuesday. And then we'll give a little, another half an hour or 45 minutes to everybody else.
Lord, it will be of great help in reducing my time, Lord. If you Lordship would go through during this, Lord.
I think what we'll do is,
Then Lordship can put the direct question to me
right,
and I'll.
what we'll do is we'll go through the written submissions of Mr. Dwivedi and Mr. Seil Singh, and possibly Dr. Guruswamy and Mr. Shankar Narayan. Any particular aspect of your submission that you would like us to focus on, because now you'd be covering things which are left out by the others.
No, but if I can just make one small submission, if your lordships have noticed, everybody on this side, there's hardly been any repetition or overlap, despite the amount of time that's been taken. And the reason I'll explain why. On day one, I told your lordship the number of pages that were involved. Your lordships have been shown only, I think, about 10 or 5, even less than 5% of the documents involved. Well, the rest of it, I'm afraid your lordship may have to go through. What we are doing, personally, I'll tell you what I'm doing. I'm putting down what I would like your lordships to read on your own, because it's going to take way too much time for me, perhaps, to take your lordships through it. There are, in fact, large swaths of material that needs to be shown, but we don't have the time.
Can I suggest one thing?
Yes.
Without giving us, like a million pages,
Yes.
if you can say by tomorrow afternoon, give to the court master on a piece of paper, what are the specific aspects you would like us to, from your submissions, as Mr. Dwivedi has given us,
Yes.
just highlight that. I'll circulate it to all my 4 colleagues,
Yes.
so that then we know exactly what is the area you're focusing on. So we'll be also ready over the weekend. We have those 2 days apart from the Monday reading. We'll focus on that. So we'll get through with the submission, so that will curtail ultimately the time which all of you are. So we proceed on the basis then that Mr. Dwivedi, Mr. Chandra Singh, Mr. Gopal Shankar Narayan, and Dr. Menka will conclude.
After that, probably my turn was there, then I think my.
Because we've all been locked in.
All right, you tell us. No, all right, you tell us what is the sequence now.
I'll take half an hour.
No, it's.
Parekh, the sequence can be, that is why I said Mr. Gopal Sankarayan can put down, you have so many minutes in Tuesday. How much minutes will each of you take? So that it should not be that anybody is left out by the end of the time.
So, Mr. Shankar Narayan, what you can do is,
Yes.
we are concluding this side completely on Tuesday. Please sit with whoever is in the court. You give us on Tuesday morning the sequence and allocation of time, so that we stick to the time, and we conclude on Tuesday at 4
I
o'clock.
suggest that I go last if I'm the one doing that, because I don't want there to be any allegation that I favor.
Oh, no, not at
I'll go
all.
last.
I don't think anybody will do that. You've been there sitting there, and you've been making notes and assisting everyone. But now when your turn comes, but give us that on Tuesday morning upfront, so that, in fact, if you can ideally give it to us tomorrow morning, give it to our Mr. Sanjay, our court master. I'll circulate it to all my colleagues. So we know Tuesday morning, and then we keep to that order, the sequence and the time. So there's, everybody feels that, they have, of course, no difficulty. Absolutely no difficulty at all.
If possible, I'll mention the issue. that each
you can even mention the interveners. Who are the interveners? Between the interveners, no difficulty. You can just right now sit with Mr. Shankar Narayan for 5 minutes after we rise, so that he can just prepare the blueprint for us.
I'll do that.
Please, one thing, this is a little bit of, self-restraint. We'll give 10 minutes, but 10 minutes provided you're saying something which is different from what somebody has argued, then don't cover the same territory. We had that, we still have it, but now we are towards almost the concluding stages of the argument. So now everybody, each one of the council following knows this is the time stipulated, and so that, we conclude on Tuesday. Otherwise, what will happen is the last 2 or 3 council will have very little time left. That should not happen. Like to ration out time for everybody, including the interveners. Mr. Shankaran, just do that, and if you could kindly give it to Mr. Sanjay by tomorrow morning, so he'll have it. Thank you.
Yes.